The Supreme Court just took action that might eliminate every single gun permit system across the United States. This is not something that might happen years from now. This is actually taking place at this very moment. The court has agreed to an emergency review of a case that directly questions whether the government has the authority to make you ask for permission before you can exercise your Second Amendment rights. This case represents the most significant challenge to gun rights since the Bruen decision, and the outcome could reshape everything almost immediately. Before we get into the details, I need you to do something really quick. Smash that like button right now if you care about protecting your Second Amendment rights. It only takes a second, and it makes a huge difference in getting this information out to more people who need it. Also, if you're not already subscribed to the channel, hit that subscribe button and turn on the notification bell so you don't miss any future updates on your rights. Trust me, you're going to want to stay informed about this stuff. Right now, the emergency review from the Supreme Court is targeting something that advocates for gun control believed could never be challenged, which is the actual permit system itself. At this moment, 25 states across the country require citizens to obtain some kind of government-issued license if they want to carry a firearm. These same states handle more than 3 million permit applications every single year. The difference between this case and the Bruen decision matters a lot. The Bruen decision got rid of may-issue systems, which were systems where government officials could use their own judgment to turn down permit requests. However, Bruen still permitted shall-issue systems to continue operating. States maintained their ability to ask for applications, charge fees, demand training, require fingerprints, and enforce waiting periods, as long as they eventually gave the permit to people who qualified. This new case completely destroys that middle ground. The people filing the lawsuit argue that making someone get any kind of government approval, no matter how fair the process appears to be, goes against the constitutional promise that the right to keep and bear arms shall not be infringed. Every single fee that gets charged, every form that needs to be filled out, every day that someone has to wait for approval represents an infringement on a fundamental right that the Constitution explicitly says cannot be restricted. Something that most people are completely unaware of is just how much money state governments are actually pulling in from these permit systems. The financial numbers might genuinely surprise you when you see them. State governments have managed to transform firearm permits into an enormous source of income. The amounts of money involved are truly remarkable. California by itself brings in more than $75 million every year just from the fees they charge for concealed carry permits. That figure does not even include the extra costs that come from mandatory training courses, which can cost anywhere from $150 to $500 for each person. In New York, the fee just to submit a permit application is $200. But after you add in what they charge for fingerprinting, what you have to pay for training requirements, and the various processing costs, the typical person in New York ends up spending somewhere between $400 and $600 just to submit an application for a permit. And that amount comes before you even consider what you will spend to actually buy a firearm. Records that have been examined show that many states are directing the money from permit fees into their general law enforcement budgets, which means these states have a financial reason to maintain these systems regardless of any constitutional questions. Some states actually raised their permit fees right after the Bruen decision came down, essentially making up for the money they lost from not being able to deny may-issue permits by charging more money to shall-issue applicants. The permit system has turned into a major source of revenue that states are fighting desperately to keep, which makes it clear why they are battling this case so hard. However, there is an even more serious issue with permit systems that goes beyond just the financial aspect, and it relates to who is actually getting their permits denied. Even in states that are supposed to be shall issue, thousands of citizens who follow the law are getting denied permits every year for reasons that have absolutely nothing to do with keeping the public safe. Based on data that was obtained through public records requests, New Jersey turned down approximately 18% of permit applications last year, despite technically being a shall-issue state after the Bruen decision. In Maryland, the rate of denials is around 12%, with many people getting denied because they failed to provide enough documentation, even in cases where they submitted everything the state asked for. California has denial rates that change dramatically depending on which county you look at, with some counties denying as many as 25% of applications, while other counties deny less than 2%. What makes this particularly troubling is the fact that most people who get denied do not file appeals, because going through the appeals process can end up costing thousands of dollars in legal fees. So, the data also reveals a disturbing pattern that keeps showing up. Permit denials affect minorities and people with lower incomes at much higher rates. In Illinois, African American applicants get denied at almost twice the rate of white applicants, even when you account for differences in criminal history. These patterns of denial expose something even more troubling about how permit systems are being used as weapons. What is currently happening in one particular state is especially outrageous. After the Bruen decision forced states to switch to shall-issue systems, states that oppose gun rights came up with a new approach. If they cannot deny permits completely, they will simply make people wait for such a long time that exercising your rights becomes virtually impossible in practice. In Hawaii, the average amount of time it takes to process a carry permit right now is 137 days. That works out to more than 4 months. New Jersey has processing times that average 92 days, even though state law says decisions must be made within 30 days. These are not accidental delays that just happen to occur. Internal emails that were obtained through Freedom of Information Act requests prove that some jurisdictions are intentionally keeping their permit processing divisions understaffed. One email from a sheriff's office in a California county clearly stated they were keeping permit processing staff at the minimum possible levels to deliberately create a backlog as their way of resisting the Bruen decision. Making matters worse, some states have put new training requirements in place that must be finished before someone can even apply for a permit. But these same states have only authorized a very small number of instructors across the entire state,
which creates waiting lists that last multiple months just to take the course that is required. But the ways that states are manipulating these systems goes even further than just creating delays. The training requirements themselves have become a constitutional problem. Training requirements sound like they make sense when you first hear about them, but states have transformed them into just another obstacle that has nothing at all to do with actual safety. Hawaii demands 16 hours of training before you can even submit an application for a permit, and the course that meets their approval costs $350, and there are only 7 instructors in the entire state who are approved to teach it. California has new training requirements that mandate 8 hours of initial training plus an additional 4 hours of renewal training every 2 years. They have made the requirements so detailed and specific that most firearms instructors who already exist cannot teach the approved courses without obtaining additional state certification that costs more than $1,000. But here is what the actual data demonstrates about these training mandates. States that have constitutional carry, which means they have no training requirements at all, have virtually the same rates of accidents and incidents involving people who lawfully carry compared to states with very strict training mandates. A study that compared crime and accident data from constitutional carry states versus states that require permits found no statistically significant difference in incidents of negligent discharge or unlawful use of force by legal carriers. Tennessee had a training requirement until 2024 when they got rid of it and switched to constitutional carry. Their data from the first year after they eliminated training requirements showed that accidents and incidents involving lawful carriers actually went down slightly. The evidence points to the conclusion that training mandates are just for show, designed to discourage people from carrying rather than being genuine measures for safety. Think about how this would work if we applied it to any other constitutional right. Imagine if you needed to apply for a First Amendment permit before you could criticize the government, where you would have to pay fees, take a class about responsible speech, go through a background check, and wait for months to get approval. Or imagine if you needed a Fourth Amendment permit before the government would recognize your right against unreasonable searches. We would instantly recognize those as unconstitutional violations. Yet we have allowed the Second Amendment to be treated as a lesser right where government permission is something that can be required. The historical record makes this absolutely clear. At the time when the Second Amendment was ratified, there were no permit requirements for carrying firearms. None at all. Citizens carried firearms openly or concealed however they wanted. The idea that you would need government approval would have been viewed as exactly the kind of tyrannical control that the founders fought a revolution against. There are 29 states that currently have constitutional carry, which proves that permits are not necessary for keeping the public safe. These states have some of the lowest crime rates anywhere in the nation, while they respect constitutional rights without putting up bureaucratic barriers. The decision that the Supreme Court makes in this case is not just going to affect permit systems. It is going to define whether the Second Amendment actually means what it says. This Supreme Court case has the potential to fundamentally change the landscape of gun rights in America. The outcome could eliminate the entire framework of permit systems that currently exist in half the states. It challenges the basic premise that has been accepted for decades, which is that the government can require citizens to seek approval before exercising a right that the Constitution explicitly protects. The implications reach far beyond just the practical matter of whether someone needs to fill out forms and pay fees. This case questions whether constitutional rights can be conditioned on government permission at all. The financial incentives that states have developed around permit systems reveal how far removed these systems have become from their supposed purpose of public safety. When states are collecting tens of millions of dollars annually from permit fees, and when they respond to court decisions by raising those fees even higher, it becomes clear that the permit system serves a different function than the one that is publicly stated. The system has become self-sustaining and profit-generating, which gives states a powerful motive to defend it regardless of constitutional concerns. The patterns of denial and delay demonstrate that even shall-issue systems, which are supposed to be fair and objective, end up functioning as barriers that prevent law-abiding citizens from exercising their rights. When denial rates vary wildly from county to county in the same state, when processing times stretch to 4 months or more, when training requirements become so expensive and difficult to fulfill that they effectively price out lower-income applicants, the system is no longer serving any legitimate purpose related to safety or responsibility. The experience of constitutional carry states provides real-world evidence that permit systems are not necessary for public safety. These 29 states have eliminated permit requirements entirely, and their crime rates and accident rates remain comparable to or better than states with strict permit requirements. This data undermines the argument that permit systems serve a compelling government interest in public safety. If public safety were genuinely at risk in constitutional carry states, we would expect to see clear evidence of that in the crime statistics. Instead, we see the opposite. Constitutional carry states demonstrate that citizens can exercise their Second Amendment rights responsibly without government oversight. If you found this information valuable, do me a favor and hit that like button right now. It helps get this critical information in front of more gun owners who need to know about these changes. And if you haven't subscribed yet, make sure you subscribe to the channel and turn on notifications so you never miss an update on your rights. Share this video with every gun owner you know because this information is too important to keep to yourself. Thanks for watching, and I'll see you in the next one.